In a world of constitutional law where brilliance should speak for itself, Terrell Washington built a career of Supreme Court victories and groundbreaking legal work. But when he arrives at the prestigious Constitutional Law Conference, he faces the same discrimination he's fought against his entire career. A powerful attorney tries to have him removed, unaware that Terrell is actually the keynote speaker. What begins as one public confrontation quickly unravels decades of systemic discrimination. As allies emerge and evidence mounts, Terrell must decide. Will he seek personal vindication or transform the entire legal profession? One moment of injustice becomes the catalyst for institutional change that will reshape American law forever. Have you ever witnessed discrimination that became a turning point for change? Share your thoughts in the comments below and join the conversation about justice in America today. Terrell Washington checked his reflection in the hotel room mirror one last time, adjusting his perfectly knotted tie. At 45, he carried himself with the quiet confidence of someone who had argued 17 cases before the Supreme Court and won 14 of them. The Constitutional Law Conference in Boston was the most prestigious gathering in his field, and this year they had selected him as the keynote speaker. "You've earned this," he reminded himself, tucking his speech notes into his Italian leather briefcase, a gift from his wife Melissa after his last major victory. The case had established new precedent for equal protection claims, and legal journals were still dissecting his innovative arguments 6 months later. His phone buzzed with a text from his daughter Amara. "Knock 'em dead, Dad, can't wait to hear all about it." A smile crossed his face. His daughter was following in his footsteps, already in her second year at Harvard Law. He texted back a quick "thanks, sweetheart," before gathering his things. Terrell had grown up in a working-class neighborhood in Philadelphia, the son of a postal worker and an elementary school teacher who had sacrificed everything for his education. His journey to becoming one of the nation's most respected constitutional lawyers hadn't been easy. As the first in his family to attend college, let alone law school, he'd faced obstacles at every turn. After graduating top of his class at Yale Law, he joined the Justice Department before eventually starting his own practice specializing in civil rights and constitutional law. His firm now employed 27 attorneys, many from backgrounds similar to his own. He had made it a personal mission to mentor young black lawyers who reminded him of himself 20 years ago. The conference organizers had sent a driver, but Terrell preferred to walk the short distance from his hotel to the convention center. The crisp autumn air helped clear his mind before big speeches. He reviewed mental notes of his keynote, Constitutional Protections in the Modern Era, expanding the framework of equal justice. As he strolled through the public garden, his phone rang. It was Richard Harrington, the conference chair and an old colleague from his Justice Department days. "Terrell. Just checking in, everything set for today," Richard's voice came through clearly. "All ready to go, just getting some fresh air before heading over." "Perfect. Remember, we're keeping your identity as the keynote under wraps until the introduction. Makes for a more dramatic moment. The program just lists special guest speaker." Terrell laughed. "Still with the theatrical flair, Richard." "Hey, these things can get stuffy. A little surprise keeps people awake." Richard paused. "Then I should warn you that Charles Whitman is here." Terrell's step faltered slightly. Whitman was a prominent attorney known for his opposition to many of the progressive legal theories Terrell championed. More concerning were the rumors about how Whitman treated younger attorneys of color at his firm. "Good to know, we've crossed paths before. Just giving you a heads up. He's brought half his firm with him, throwing his weight around as usual." "Nothing I haven't handled before," Terrell replied confidently. As he approached the gleaming convention center, Terrell noticed groups of attorneys in expensive suits already networking on the steps. Several nodded in recognition as he passed. His book on constitutional interpretation had become standard reading in law schools across the country. Terrell checked his watch, 7 a.m. The keynote wasn't until 11, but he wanted to attend the opening panel discussion. He took a deep breath, straightened his shoulders, and walked up the steps toward the entrance, unaware that in just a few hours, his presence at this conference would trigger a confrontation that would change the trajectory of his career and the legal community's approach to racial bias. The convention center lobby buzzed with activity as attorneys from across the country networked over coffee. Terrell navigated through the crowd, nodding at familiar faces. The Constitutional Law Conference had always been his favorite professional gathering, a place where legal minds challenged each other and advanced the field. As he approached the registration desk, a young white woman with a conference badge reading staff looked up, her smile polite but distant. "Good morning," Terrell said. "I'm here to pick up my credentials." "Name?" she asked, not making eye contact as she shuffled through papers. "Terrell Washington." She scanned her list, flipping through several pages. "I don't see you registered as an attendee. Are you sure you're at the right conference? This is the Constitutional Law Conference." Terrell maintained his calm demeanor. Yes, I'm certain. Could you check again? I should be on a special list. The woman sighed audibly. Sir, I've checked the entire attendee list. Maybe you registered late. The vendor tables are in the back if that's why you're here. A tall man behind Terrell cleared his throat impatiently. Some of us have panels to attend. Terrell stepped aside, pulling out his phone. Let me call Richard Harrington. He's the conference chair. Oh, you know Richard. Her tone shifted slightly, though skepticism remained. Before Terrell could respond, Charles Whitman approached the desk, flanked by 3 junior associates. At 60, Whitman was a commanding presence, silver-haired, expensively dressed, and accustomed to deference. Margaret, lovely to see you again, Whitman boomed, completely ignoring Terrell. Mr. Whitman, your credentials are right here, she said, immediately producing an envelope with VIP badges. Whitman distributed the badges to his associates, then finally acknowledged Terrell with a dismissive glance. Having trouble, this registration is for confirmed participants only. I'm well aware, Terrell replied evenly. Whitman looked him up and down. Don't I know you? You're with that civil rights group, aren't you? I have my own practice, actually. Terrell Washington. Recognition flickered in Whitman's eyes, but he merely shrugged. Well, good luck sorting out your registration issue. He turned to his associates. Let's get good seats for the federal judiciary panel. As they walked away, Terrell overheard Whitman mutter, security's really slipped at these events. They'll let anyone walk in claiming to be an attorney these days. One of the younger associates glanced back at Terrell apologetically. Terrell was texting Richard when a different conference organizer approached the desk. Is there a problem here? This gentleman claims he should be registered, but he's not on any of my lists, the receptionist explained. Your name, sir? The organizer asked. Terrell Washington. The organizer's eyes widened. Oh, Mr. Washington, I'm so sorry about this confusion. You're absolutely right, you're on our VIP list. He shot a disapproving look at the receptionist. Margaret, Mr. Washington is our keynote speaker. Margaret's face flushed. I'm so sorry, sir, I didn't realize. It's fine, Terrell said, though it wasn't. The organizer handed him a special badge with speaker prominently displayed. Please let me show you to the speaker's lounge. There's breakfast waiting and Richard was looking for you. As they walked away, Terrell noticed several attendees watching the interaction, including one of Whitman's young associates who had witnessed the entire exchange. In the speaker's lounge, Richard greeted him warmly. Terrell, glad you made it. Everything okay? You look a bit tense. Just a small issue at registration, Terrell replied, keeping his voice low. Richard frowned. What happened? As Terrell recounted the incident, his friend's expression darkened. That's unacceptable. I'll speak with the staff immediately. It's not just the staff, Terrell said. I ran into Charles Whitman. Already, that didn't take long, Richard sighed. Did he say something? Nothing direct, just the usual subtle jabs, Terrell shrugged. Nothing I haven't dealt with before. A young black woman approached them, extending her hand. Mr. Washington, I'm Zoe Taylor, third-year associate at Reynolds & Burke. I've studied all your cases. Your argument in Washington v. Federal Communications Commission was brilliant. Terrell smiled genuinely for the first time that morning. Thank you, Ms. Taylor. Always good to meet the next generation. I was hoping to attend your keynote, she continued, but I've been assigned to assist Mr. Whitman during that time slot. Richard interjected, I think Mr. Whitman can spare you for an hour. Zoe hesitated. He's very particular about his schedule. I'll handle Whitman, Richard assured her. Sometimes the old guard needs reminding that times are changing. As they spoke, Terrell noticed Whitman across the room, holding court with several judges. Their eyes met briefly and Whitman's smile faltered. The first panel was about to begin. Terrell checked his notes one more time, unaware that Whitman was already working to undermine his presence at the conference. The morning panels proceeded smoothly, with Terrell participating in discussions and asking thoughtful questions from the audience. During the mid-morning break, he stepped into the hallway to review his keynote notes one final time. As he scrolled through his tablet, Terrell overheard a heated conversation around the corner. I don't care who invited him, Charles Whitman's distinctive voice carried clearly. He's built his entire career attacking the foundations of constitutional interpretation. Having him as keynote sends the wrong message about this conference. A second voice responded, lower and hesitant. Richard specifically selected him because of his innovative approach. The committee voted unanimously. The committee wasn't fully informed, Whitman countered. Washington pushes an agenda that undermines judicial precedent. He's a political activist, not a serious constitutional scholar. Terrell considered walking away but decided against it. This was precisely the kind of behind-the-scenes opposition he'd faced throughout his career. He calmly rounded the corner. If you have concerns about my academic qualifications, Charles, I'd be happy to discuss them directly, Terrell said. Whitman turned, momentarily startled. The young man he'd been speaking with, a conference organizer named David, looked mortified. Terrell, Whitman recovered quickly. This was a private conversation. About me in a public hallway, Terrell noted. Not particularly private. Whitman straightened his tie. I was simply expressing my professional opinion that your approach to constitutional law is problematic. Yet you expressed it to a conference organizer rather than to me, Terrell said. I wonder why. Several attendees had begun to notice the exchange, slowing their pace to observe. Whitman lowered his voice. This isn't the place for this discussion. I agree completely, Terrell replied, which is why I'm surprised you were attempting to undermine my keynote address. I was doing no such thing, Whitman scoffed. But since you've brought it up, many of us have serious concerns about having someone with your perspective representing this conference. My perspective? Terrell maintained his calm demeanor. You mean my legal analysis that's been cited by the Supreme Court 11 times? David, the young organizer, attempted to intervene. Gentlemen, perhaps we should. Let me be clear, Whitman interrupted, his voice rising. People like you are invited to these events as a courtesy, but don't mistake inclusion for acceptance of your radical ideas. The hallway had grown silent. At least 20 attorneys now watched the confrontation unfold. People like me? Terrell asked quietly. You know exactly what I mean, Whitman said, stepping closer. Attorneys who use identity politics instead of sound legal reasoning. Exploit historical grievances for professional advancement. A murmur ran through the growing crowd. Terrell waited a beat before responding. I believe my record speaks for itself. 17 Supreme Court appearances, 14 victories, 3 books on constitutional theory taught in law schools nationwide. His voice remained measured. What specifically about my legal reasoning do you find unsound? Whitman's face reddened. This isn't about your credentials. Then what is it about, Charles? Security. Whitman suddenly called out, turning to a nearby uniformed guard. This man is creating a disturbance. He's harassing me. The security guard approached uncertainly. Sir, this man needs to be removed, Whitman insisted. He's disrupting the conference and became confrontational when I tried to walk away. Several witnesses exchanged shocked glances. That's not what happened, a voice called from the crowd. It was Zoe Taylor, the young associate who had spoken with Terrell earlier. Mr. Washington was responding to comments Mr. Whitman made about him. The security guard looked confused. Sir, do you have conference credentials? He does not belong here, Whitman insisted before Terrell could answer. Check his badge, it's probably fake. Terrell calmly displayed his speaker badge. I'm the keynote speaker this afternoon. The guard looked embarrassed. I'm sorry, sir, there seems to be a misunderstanding. The misunderstanding, Whitman snapped, is that this conference has apparently lowered its standards. I've been attending for 20 years and never has the keynote been given to someone so clearly unqualified. Richard Harrington pushed through the crowd. What's going on here? Your keynote speaker confronted me in the hallway, Whitman claimed. I was having a private conversation. That's not true, David interjected. Mr. Whitman was telling me the keynote speaker shouldn't have been invited and called him a political activist. Richard's expression hardened. Charles, I think we need to talk privately. No need, Whitman said dismissively. I'm simply expressing the concerns of many attendees. This conference has a reputation to maintain. Yes, it does, Richard agreed. Which is why we invited one of the most accomplished constitutional lawyers in the country to deliver our keynote. Whitman scoffed. Accomplished? By what measure? The confrontation had now drawn nearly 50 onlookers, including several federal judges and law school deans. By every objective measure in our field, Richard said firmly. Now I suggest you reconsider your position and your tone. Or what? Whitman challenged. Or I'll have to ask you to leave, Richard replied. Not Mr. Washington. Whitman looked around, suddenly aware of the crowd and the numerous phones discreetly recording the interaction. His expression shifted from confrontational to calculating. This isn't over, he said quietly to Terrell before walking away, gesturing for his associates to follow. As the crowd dispersed, Richard turned to Terrell. I'm so sorry about this. Don't be, Terrell replied. It's nothing new. What neither of them realized was that one of those recordings was already being uploaded to social media, where it would soon go viral in legal circles and beyond. Following the confrontation, the conference atmosphere shifted palpably. As Terrell made his way toward the luncheon area, attendees who had previously ignored him now approached with supportive comments and business cards. That was completely unprofessional of Whitman, said Elena Rodriguez, a federal appellate judge. His behavior was unacceptable. Thank you, Your Honor, Terrell replied. Unfortunately, it's not uncommon. Perhaps not, Judge Rodriguez acknowledged, but having it happen so publicly might actually serve a purpose. Richard caught up with Terrell as they entered the dining hall. The conference board is meeting right now about Whitman's behavior. Several members wanted you to know they're fully supportive of you. At a corner table, Terrell noticed 3 of Whitman's associates huddled in conversation, occasionally glancing his way. Their expressions suggested internal conflict rather than hostility. Mr. Washington, a voice came from behind him. Terrell turned to find a young white man in his early 30s offering his hand. James Bennett, I clerk for Justice Sandoval at the Supreme Court. I've studied all your cases. A pleasure to meet you, James. Sir, I was with Mr. Whitman's group this morning, James confessed. I need to speak with you about something important. Richard raised an eyebrow, but Terrell nodded. Of course. James lowered his voice. This isn't the first time Mr. Whitman has behaved this way. At his firm, there's a documented pattern of discrimination against black attorneys. I've witnessed it firsthand during my summer associate position there. Why are you telling me this? Terrell asked. Because someone needs to stop him and you might be the only one who can. James pulled out his phone. I have emails, documentation of similar incidents with other black attorneys who interviewed or worked briefly at the firm. Richard interjected, you should be careful about sharing confidential firm communications. I've consulted with ethics counsel, James replied. These communications reveal potential civil rights violations. They're not privileged. Before they could continue, Zoe Taylor approached their table. Mr. Washington, I apologize for interrupting, but there's something you should know. She placed her tablet on the table. The video of your confrontation with Mr. Whitman has been shared extensively among conference attendees. The screen showed a social media post with over 2,000 shares already. The caption read, Prominent white attorney tries to have black keynote speaker removed from constitutional law conference. It's already being picked up by legal blogs, Zoe added, and several of Mr. Whitman's former associates are commenting with their own stories. Richard scrolled through the comments. This is unprecedented. I never wanted this kind of attention, Terrell said quietly. Sometimes the moment chooses you, Judge Rodriguez commented, joining them. Terrell, the Judiciary panel speakers would like you to join us this afternoon. We're modifying our topic to include a discussion on equity in the legal profession. As they spoke, more attendees approached to offer support. Professor Janet Lynn from Berkeley Law introduced herself. My constitutional law students watch your Supreme Court arguments as examples of excellence. What happened today only underscores why your perspective is so vital. The conference director arrived, looking harried. Mr. Washington, the board extends its sincere apologies for this morning's incident. We're addressing it immediately. What does that mean exactly? Richard asked. Mr. Whitman has been asked to issue a public apology or leave the conference, the director explained. He's currently refusing both options. James Bennett spoke up. I think there are larger issues than just today's incident. I agree, said another voice. A distinguished older black attorney approached their table. Marcus Gaines, Mr. Washington, I've admired your work for years. Terrell recognized him immediately, a civil rights lawyer who had broken barriers in the 1970s. The honor is mine, sir, Terrell responded. I witnessed similar treatment 30 years ago, Marcus said. The difference today is that you have allies, documentation, and a platform. He gestured around the table. Use it. As lunch concluded, Richard received a text message. Whitman's trying to organize a walkout during your keynote, he told Terrell quietly. Let him try, Judge Rodriguez interjected, having overheard. I'll be sitting front row and I won't be alone. Looking around at the diverse group that had gathered, judges, professors, young associates, and established attorneys of all backgrounds, Terrell realized something significant was happening. This wasn't just about one conference confrontation, it was about addressing patterns that had persisted throughout the legal profession for decades. His phone buzzed with a message from his daughter. Dad, you're trending in legal circles, so proud of you for standing your ground. Your keynote starts in 30 minutes, Richard reminded him. Are you ready? Terrell nodded, more determined than ever. I think I might need to revise my speech slightly. As they left the dining hall, Terrell noticed Whitman watching from across the room, his face a mask of barely contained anger. But unlike earlier that morning, Whitman now stood alone. The main conference hall filled rapidly as the time for Terrell's keynote approached. The room, designed to hold 400 attendees, was standing room only. Judges, professors, practicing attorneys, and law students packed the space, creating a palpable energy unlike typical academic conferences. Richard stepped to the podium at exactly 2 p.m. Good afternoon, everyone. Before I introduce our keynote speaker, I want to address this morning's unfortunate incident. A hush fell over the audience. The Constitutional Law Conference has always stood for the rigorous examination of legal principles in an environment of professional respect. This morning, one of our attendees failed to uphold these standards. Richard's voice was firm. The board has unanimously condemned this behavior and is taking appropriate action. In the third row, Charles Whitman sat stone-faced, flanked by two remaining associates. Many of his other colleagues had distanced themselves, choosing seats elsewhere. Now it is my honor to introduce our keynote speaker, Richard continued. His legal scholarship has reshaped constitutional interpretation in areas ranging from equal protection to First Amendment jurisprudence. With 17 Supreme Court appearances and 14 victories, he has established precedents that will impact American law for generations. Whitman whispered something to one of his associates, who looked increasingly uncomfortable. On his courtroom success, his academic contributions include 3 definitive textbooks on constitutional theory used in law schools nationwide. The American Bar Association recently named him among the 20 most influential attorneys of the past decade. Whispers circulated as those unfamiliar with Terrell's accomplishments began to understand the magnitude of Whitman's misjudgment. Please welcome our keynote speaker, Terrell Washington. Applause erupted as Terrell approached the podium. In the front row, Judge Rodriguez led several federal judges in a standing ovation. Behind them, Marcus Gaines stood proudly, joined by a diverse coalition of attorneys spanning multiple generations. Terrell adjusted the microphone, scanning the room before speaking. His gaze briefly met Whitman's before moving on. Thank you for that warm welcome. My prepared remarks today were titled Constitutional Protections in the Modern Era. However, given this morning's events, I hope you'll indulge me in addressing a more immediate topic. He paused, taking a sip of water. The Constitution begins with 3 powerful words, we the people. Not we some people or we certain people, but we the people. Yet throughout our nation's history, the legal profession has struggled to embody this inclusive promise. Terrell removed his prepared notes from the podium, setting them aside. This morning, many of you witnessed or heard about an incident that occurred between myself and another conference attendee. What happened was not unique or unusual, it was merely visible. The room remained silent, completely focused on his words. For every confrontation you witness, there are hundreds that occur behind closed doors. For every explicit bias caught on camera, thousands of implicit biases shape hiring decisions, partnership offers, and client relationships. In his row, Whitman shifted uncomfortably as several heads turned toward him. I did not become a constitutional lawyer to win cases, Terrell continued. I became a constitutional lawyer because I believe in the document's transformative potential, its capacity to evolve toward a more perfect union. The same is true for our profession. From the back of the room, a door opened. A conference organizer rushed in, handing Richard a note. Richard read it quickly, his expression changing. He approached the podium, whispering something to Terrell, who nodded and stepped back. Ladies and gentlemen, Richard addressed the crowd, I've just been informed that an emergency meeting of the American Bar Association Ethics Committee has been called. Significant evidence has been presented regarding systematic discrimination at Preston, Whitman, and Associates spanning the past 15 years. Gasps echoed through the hall. Charles Whitman stood abruptly. This is outrageous, what evidence? From the middle of the audience, James Bennett stood. The evidence I provided, Mr. Whitman, documentation of hiring practices, internal communications, and testimony from 17 former associates. You had no right, Whitman shouted. He had every right, came another voice, Zoe Taylor, as did I and the others who have come forward. Richard raised his hand for quiet. The Ethics Committee has asked Mr. Washington to review the evidence and provide his professional assessment. Given his expertise in civil rights law, they believe his perspective would be invaluable. Whitman's face reddened further. This is a setup, a coordinated attack on my reputation, Judge Rodriguez spoke from her seat. Mr. Whitman, I suggest you refrain from further outbursts. This is neither the time nor place. Terrell returned to the podium. I had no knowledge of this investigation until this moment. However, I'm willing to assist the Ethics Committee in any way that serves the interests of justice. Whitman pointed at Terrell accusingly. You orchestrated this, you and your social justice warriors conspiring to destroy careers over perceived slights. The room erupted in murmurs. Mr. Whitman, Terrell responded calmly, what you call perceived slights, the law recognizes as discrimination. What you dismiss as social justice, our Constitution demands as equal protection. One of Whitman's remaining associates quietly got up and walked away from him, moving to sit elsewhere. This conference is about constitutional law, Terrell continued, and there is perhaps no more fundamental constitutional principle than equal justice under law. It's inscribed on the very facade of our Supreme Court. The audience broke into spontaneous applause. Even those who had initially seemed skeptical now appeared supportive. I will now continue with my keynote, Terrell said, not about my experiences today, but about our collective responsibility to uphold constitutional principles in our profession and our society. As Terrell launched into his prepared remarks, Whitman stormed toward the exit alone. The door closed behind him with a decisive click that seemed to punctuate the end of one era and the beginning of another. The afternoon sessions proceeded with an electric atmosphere throughout the conference center. Terrell's keynote had received a standing ovation, with numerous attendees approaching him afterward to express their support and share their own experiences. Meanwhile, news of the Ethics Committee investigation spread rapidly through legal circles and beyond. By 5 p.m., Terrell found himself in a hastily arranged meeting with the conference board. the ABA Ethics Committee representatives who had arrived on site, and several senior attorneys who had come forward with additional evidence against Whitman's firm. "The documentation is substantial," said Elaine Winters, the Ethics Committee chairperson, spreading files across the conference room table. 15 years of systematic discrimination in hiring, promotion, and case assignments. Plus compensation disparities that appear directly correlated with race, added James Bennett, who had been compiling data throughout the afternoon. Black associates were consistently assigned lower-value cases despite comparable credentials. Richard examined a spreadsheet. "These numbers are damning. Has Whitman responded to any of this?" "His attorney contacted us 30 minutes ago," Elaine replied. "They're claiming the data is being misinterpreted and threatening legal action against the ABA if we proceed." Terrell reviewed the documents carefully. "These patterns are too consistent to be coincidental. The statistical probability of this occurring by chance is virtually zero." A knock at the door interrupted them. Zoe Taylor entered, looking simultaneously nervous and determined. "I have something to add," she said, placing a USB drive on the table. "Audio recordings from partner meetings at Preston, Whitman and Associates. Mr. Whitman was explicit about his hiring preferences." "How did you obtain these?" Elaine asked cautiously. "I was tasked with taking minutes at these meetings," Zoe explained. "The firm records all partner meetings for record-keeping purposes. As the most junior associate present, I was responsible for the recording equipment." Richard looked concerned. "The legality of sharing these recordings has been vetted by Employment Counsel," Zoe finished. "Massachusetts is a one-party consent state for recordings. Additionally, the firm's own policy states these recordings are for business documentation purposes, which includes compliance with anti-discrimination laws." Terrell nodded appreciatively at her thoroughness. As the recordings played, Whitman's voice filled the room. "We need to be selective about who represents our firm to clients. The Preston Whitman brand has certain expectations. Our clients are comfortable with attorneys who reflect traditional values." Another voice asked, "Are you suggesting we shouldn't hire the Howard graduate? Her credentials are stellar." "I'm suggesting," Whitman responded slowly, "that cultural fit matters as much as credentials. Find a reason, low writing sample score, poor interview performance, whatever works." Elaine stopped the recording. "There are 12 more like this spanning 7 years. The door burst open without warning. Charles Whitman stood there, flanked by a man in an expensive suit, presumably his attorney. "This is an illegal meeting and those recordings were obtained unlawfully," the attorney declared. "My client demands all copies be destroyed immediately." "This isn't a court proceeding, Mr. Cunningham," Elaine replied calmly. "It's an ethics investigation which the ABA is fully authorized to conduct." "Charles," Richard said, "I think it would be better if you—" "Charles me," Whitman snapped. "You orchestrated this entire charade. Bringing in Washington as keynote was a deliberate provocation." "I was invited because of my legal accomplishments," Terrell stated simply. "You were invited because of politics." Whitman's face had grown increasingly red. "This profession is being destroyed by diversity mandates and social engineering." His attorney placed a restraining hand on his arm. "Charles, that's enough." "No, let him continue," Terrell said quietly. "The record should be complete." Outside the conference room, a small crowd had gathered, including several journalists who had arrived to cover the rapidly developing story. Whitman seemed beyond caring about the audience. "You people always play the victim while systematically pushing out those of us who built this profession. You use words like inclusion and equity to mask your agenda." "And what agenda would that be?" Terrell asked. "Lowering standards, replacing merit with identity," Whitman was shouting now. "I've earned everything I have through hard work, not by crying discrimination at every turn." The room fell silent. Whitman's attorney closed his eyes in evident dismay. Terrell stood slowly. "Mr. Whitman, I graduated first in my class at Yale Law. I've won 14 Supreme Court cases. I've authored 3 definitive texts on constitutional law, yet this morning you assumed I didn't belong at this conference." He paused. "That's not bias, what would you call it?" "Coincidence," Whitman muttered. "One isolated incident." "The data suggests otherwise," Elaine interjected, gesturing to the files. "Fabricated data, out-of-context recordings." Whitman's composure had completely dissolved. A flash went off as someone in the doorway took a photograph. Whitman's attorney finally pulled him away from the doorway. "This meeting is adjourned," Elaine announced. "The Ethics Committee will issue its preliminary findings tomorrow morning." As the room cleared, Richard approached Terrell. "I've never seen anything like this." "I have," Terrell replied softly, "just never so publicly documented." Outside, reporters were already filing stories. By morning, Charles Whitman's meltdown would be front-page news in every legal publication in America. 6 months after the Constitutional Law Conference, Terrell Washington stood at the podium in the ABA headquarters in Chicago. The room was filled with legal professionals, journalists, and law students who had gathered for the unveiling of the Equal Justice Initiative, a comprehensive program to address systemic bias in the legal profession. Today marks not an end but a beginning, Terrell stated, surveying the attentive audience. The incidents that catalyzed this initiative revealed patterns that have persisted too long in our profession. What's different now is our collective commitment to measurable change. Behind him sat an impressive coalition: 5 federal judges, 12 law school deans, the ABA president, and representatives from over 50 major law firms. The most significant absence was Charles Whitman, whose spectacular downfall had become a cautionary tale throughout the legal community. The Ethics Committee investigation resulted in unprecedented sanctions, Terrell continued. Preston, Whitman and Associates has been dissolved, with its remaining partners establishing a new firm under completely restructured leadership and policies. The investigation had ultimately uncovered discrimination affecting 73 attorneys over 15 years. The financial settlement exceeded $42 million, but the structural reforms were equally significant. Today we're implementing a comprehensive framework with 3 core components, Terrell explained, displaying a detailed slide. First, transparent hiring metrics across participating firms. Second, anonymous reporting mechanisms with real investigative capacity. Third, accountability measures with concrete consequences. Richard Harrington approached the podium. We've secured commitments from 78% of AM Law 100 firms to implement these standards. Each participating organization will undergo annual compliance audits with results publicly reported. Zoe Taylor, now working as special counsel to the initiative, presented the data tracking system. This dashboard provides real-time analytics on demographic patterns in hiring, retention, case assignments, and partnership tracks. Anomalies trigger automatic review protocols. From the audience, James Bennett raised his hand. How will this affect smaller firms and solo practitioners? Excellent question, Terrell responded. We've developed scalable implementations for organizations of all sizes. Additionally, the ABA will provide implementation support at no cost to smaller firms. After the formal presentation, Terrell found himself surrounded by attendees eager to discuss next steps. Judge Rodriguez approached with a warm smile. "When I saw you at that conference, I never imagined we'd be here 6 months later," she said. "You've transformed a personal attack into institutional progress." "Not alone," Terrell replied. "This happened because people at every level chose to act." His phone buzzed with a message from his daughter Amara. "Dad, just saw the press conference streaming. My entire study group is watching. You're making history." Marcus Gaines, now serving as senior advisor to the initiative, joined them. 50 years fighting for change, and this is the most significant reform I've seen. The difference is data and documentation. They can't deny what's plainly recorded. Later that evening, at a small dinner celebrating the launch, Richard raised a toast to Terrell, who turned confrontation into transformation. Terrell shook his head. "To all of us, especially those who took risks." He nodded toward Zoe and James. "Without their courage in coming forward with evidence, nothing would have changed." 2 young black law students approached their table, introducing themselves tentatively. "Mr. Washington," one said, "we're starting a journal focused on constitutional equity at our law school. Would you consider being our faculty advisor?" "I'd be honored," Terrell replied, "though I'm not faculty." "Actually," Richard interjected, "Yale Law has been trying to recruit you for their constitutional law chair. Perhaps it's time to consider it." Terrell smiled thoughtfully. "Teaching the next generation, there's power in that." As the evening wound down, Terrell stepped outside for a moment of quiet reflection. His phone rang, Melissa calling to check in. "How did it go?" she asked. "Better than I expected," he replied. "Real commitments, real resources." "I'm proud of you," she said. "You didn't just win a case, you're changing the system." Terrell looked back through the window at the diverse group of legal professionals united in purpose. It's never been about winning or losing, it's about progress moving the law closer to its highest ideals. "So what's next?" Melissa asked. Terrell thought for a moment. "The initiative is launched. The metrics are in place. Now comes the harder part, sustaining momentum through inevitable resistance." "You won't be facing that resistance alone," she reminded him. "No," he agreed, watching as more young lawyers joined the gathering inside. "That's the most important change of all." The next morning, Terrell would wake to headlines announcing the initiative and analyzing its potential impact. Legal blogs would debate its merits. Some would resist. Others would embrace it enthusiastically. But regardless of reaction, the conversation had fundamentally shifted. What had begun as a confrontation at a conference had catalyzed a movement for lasting institutional change. Proof that the Constitution's promise of equal justice, while still imperfect in execution, remained a powerful force for transformation when placed in determined hands.